Thanks, David. After such a formidable introduction, I feel an immense amount of pressure to say something that you're going to actually really enjoy or learn from. But without being too academic about it, I'm here today to talk about the UN Security Council resolutions that related to the former Yugoslavia and the UN Security Council resolutions. There were only two for Libya, and how they related to the Canadian Forces employment and operations in those two missions. So thanks very much for the invitation. The military operations in former Yugoslavia, which began in the 1990s, and the operations in Libya in 2011 were both authorized by the UN Security Council. The objective of my remarks to you today is to place those UN Security Council resolutions which authorize those operations in their legal context for the Canadian Armed Forces. I was not deployed to the former Yugoslavia, but have consulted extensively with a fellow military lawyer who's now a Justice of the Peace here in Edmonton. I've consulted with him. He served as an air operations legal advisor during the 1999 Kosovo air campaign. The NATO name for that mission was Operation Allied Force. I myself deployed to Europe in support of the Canadian Forces operations in Libya, which the Canadian Forces title for that one was Operation Mobile, and that was early in 2011. The way I propose to do this, I'm going to look at the matter from the top-down perspective of how UN authorization fits into the range of legal authorities for international operations by the Canadian Forces. And then I'm going to look at the significance of a UN Security Council resolution for those planning and commanding operations. I'll suggest that while a lot has changed in the world between 1992 and today, a UN Security Council resolution, it remains the optimum authority for international operations by the CF that use force. But in an era in which the rules-based international order is under threat, it's important for you to know and to recall that there are sources of legal authority for the use of force other than UN Security Council resolutions. So for Canada, the use of military force in an international operation requires a valid legal basis that rests both on domestic law and international law. That is to say, before getting to the issue of what international law basis exists to deploy the Canadian Forces outside of Canada, there must be a basis in Canadian law to do so. And that basis is not found in the Constitution. It's not found in the National Defense Act. It resides in a venerable legal concept known as the royal prerogative. And this is one of the things that separates us from, as a constitutional monarchy, from a republic. We have this very useful legal authority called the royal prerogative or the crown prerogative. And basically, it's the authority that belongs to the executive branch of government and is exercised without needing the approval of Parliament. It represents essentially the authority of the sovereign that has not been eroded by Parliament by passing legislation. So areas such as conduct of foreign affairs, the bestowal of titles and honors, and importantly, the deployment of the armed forces in defense of Canada all fall under the authority of the King, and in practice are exercises of discretion by the Prime Minister and the Privy Council. The so what for all that is the House of Commons motions in support of an overseas deployment of the Canadian Forces are just that. They're motions, they're expressions of consensus, and they have political weight, but they are not a legal requirement to deploy the Canadian Forces overseas. The royal prerogative or the crown prerogative, the exercise of authority by the Prime Minister and the Cabinet, approved by the Governor General on behalf of the King, is the primary domestic legal authority for international deployments. So, the exercise of the Crown prerogative to authorize the deployment of the Canadian Forces will always depend on the government of the day being satisfied that there is a basis for the mission in international law. And that is where United Nations Security Council resolution comes in. In the post-World War II international system, most bases for lawful use of force are connected one way or another to the UN Charter. To understand then where a Security Council resolution fits in, it's worth taking a moment, which I'm going to consider the role the UN has played since its creation. The language of the preamble to the UN Charter was influenced by the failure of the international community to prevent catastrophic conflicts twice in the early 20th century. The most important words from the Charter in this regard are briefly to quote, "We the peoples of the United Nations, determined to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind." So there was an enormous resolve at the end of the Second World War, and I'm old enough, both my parents served in the Second World War. In fact, that's where they met. It was a world-changing event. I'm sure I don't have to overemphasize that. And that generation of leaders around 1944 to 1946 who were establishing the United Nations were determined that it would serve as an effective organization because its predecessor, the League of Nations, had been ineffective. They wanted the UN to be an effective organization that would prevent or intervene to halt an armed conflict. And to that end, Article 1 of the Charter stated that the purposes of the UN are to, quote, "maintain international peace and security, and to do so by, quote, effective collective measures for the prevention and removal of threats to the peace and for the suppression of acts of aggression or other breaches of the peace." So in taking that approach, the UN Charter established two legally important things. First, the UN could act in a preemptive manner to prevent armed conflict. And secondly, that the preferred means of acting would be collective action authorized by the UN Security Council. The challenge this gave rise to was that the international system up to World War II had been based on, above all, the sovereignty and independence of nation states to do as they saw fit. So this approach, collectivism, preemptive action to prevent conflicts or to extinguish them, required a balance between acceptance that the United Nations could intervene to deal with threats to international peace and security, with the need to respect the centuries-old tradition based on the, this is going to sound really academic, but the Treaty of Westphalia, some of you are probably familiar with, that whole tradition that sovereign states are autonomous and their interests prevail over any other entity or concern, including humanitarianism. And this was where the end of the Second World War saw a lot of other developments in diplomacy and law, particularly the 1949 Geneva Conventions, which don't deal with the conduct of hostilities. They deal with protection of the sick and wounded, protection of civilians, protection of prisoners of war. So those are all, one way or another, rooted in humanitarianism. They're certainly not rooted in respect for individual states' sovereignty and independence. So the UN was trying to balance these two goals. They couldn't just dispense with the Westphalian tradition, but there was a significant resolve to proceed on the basis of collective action and prevention of aggression. They tried to do that through two provisions in particular, one that prohibits the use of force or threats of force between states, and a second one that, and it balances it off, binds the UN to not intervene in matters that are essentially within the domestic jurisdiction of any state. So in other words, the UN Charter established that aggression between states was prohibited, but that actions taken by states in conducting their internal affairs are none of the United Nations business. This ran the risk that states would engage in aggression, but seek to characterize it as fundamentally domestic in character in order to avoid United Nations directed intervention. And the weakness in this approach became apparent when a state disintegrated and the components of it were extremely hostile to each other, as was the case in the former Yugoslavia. At least twice during the course of the conflict in the former Yugoslavia, the UN Security Council was unable to reach consensus and issue a resolution that clearly authorized the use of force to protect civilians. First in Srebrenica in 1995, and secondly in relation to Kosovo in 1999. Before I discuss a little bit more detail about how the shortcomings in the Security Council resolutions impacted the UN mission in the former Yugoslavia, it's worthwhile to take a look at why Security Council resolutions are significant. The UN Charter expressly bestows on the Security Council the primary responsibility for the maintenance of international peace and security, not the General Assembly. And it makes the Security Council the part of the UN that speaks for and authorizes military action on behalf of member states. In other words, it authorizes the use of armed force. In cases in which an armed conflict is imminent or has already broken out, the Security Council can act under Chapter 7 of the UN Charter, which is titled Action with Respect to Threats to the Peace, Breaches of the Peace, and Acts of Aggression. But remember, around the time when things started to heat up in the former Yugoslavia, the vast majority of UN operations have been authorized under Chapter 6, not Chapter 7. Chapter 6 is the authority for peacekeeping operations, where parties to an imminent conflict agree to invite the UN in, and the whole goal is to prevent a conflict from breaking out. There wasn't a lot of experience, and because of the Cold War and because of the tendency of the superpowers to cancel each other out at the Security Council with their vetoes, there wasn't a lot of experience with Chapter 7 operations. So, Chapter 7, well, it makes clear that the Security Council gets to determine if something constitutes a threat to international peace and security. And it gives it the power to take actions by, quote, air, land, or sea forces as may be necessary to maintain or restore international peace and security. There just wasn't a lot of practical experience, I would argue, in the UN in actually authorizing such a mission. Clearly then, although they didn't have experience at it, the Security Council had both the right and the responsibility to identify and direct an armed response to an act of aggression. I need to point out, though, that this is all great in theory, and it looks beautiful on the page as part of the UN Charter, but the reality is the immediacy of the situation during an armed attack will often demand that the state which is being attacked must respond at once before the Security Council has taken the matter up. So in recognition of this, the UN Charter usefully recognizes the right of member states to use force in self-defense, both individually and collectively. The Charter of the UN recognizes that standing regional arrangements, security arrangements can be created, and it also says that they can be used for UN enforcement action. So, as we all know, the action taken by the world in relation to former Yugoslavia was authorized by the UN, but it was led by NATO, a regional security arrangement. However, the use of force in self-defense and the use of force collectively for self-defense, although they long predated the United Nations, and although they were recognized by the UN Charter, and are subject to a provision in the Charter which says that they can only take that action until the Security Council has authorized action of its own. So in many cases, we've seen both in former Yugoslavia and later, action was taken by a regional alliance, and when that was approved by the Security Council, it essentially endorsed the action that had already been taken and allowed it to continue. But that isn't necessarily always the case. And why is that legally significant? Because when Canada acts, we will, as we're required to by the Charter, actually file a record with the UN that we're taking action in a collective self-defense, and we're reporting it to the UN Security Council. How the UN Security Council decides to proceed can vary from case to case. Anyway, getting back to the former Yugoslavia, something else was happening just at that era, something very significant legally. I talked earlier about the resolve at the end of the Second World War to give a lot more weight to humanitarian concerns, even at the cost of state sovereignty. At the time, a new legal concept relating to authority for the use of force was coming to the fore, one which was distinct from both self-defense and use of force on the basis of a Security Council resolution. And this concept, and I speak about it in the past tense because, as I'm going to get to, it never really crystallized. This concept was known as the responsibility to protect, sometimes known as the right to protect. And it refers to the authority to use force to protect individuals when their home state is unwilling or unable to protect them. In other words, an authority to use force based on humanitarian grounds. The most controversial formulation of the concept was that states have not only a right but an obligation to take steps, to take action in response to a humanitarian crisis arising from state aggression. The problem then, as it is now, was that responsibility to protect, or if you're an academic in this area, like to call it R2P. R2P was not part of the UN Charter, nor was it recognized as international customary law at the time or since. So, in fact, in former Yugoslavia, the phrase and the concept responsibility to protect was never actually invoked by the United Nations. And interestingly, it was actually invoked by NATO. This happened most notably in 1999 when NATO relied upon responsibility to protect as the legal basis for the Kosovo air campaign at a time when there was no UN Security Council resolution authorizing the use of force to stop ethnic cleansing in Kosovo. So this was very interesting if you're a military lawyer, because the alliance that was acting on behalf of the UN had actually gotten out in front of the UN in terms of its willingness to be proactive and aggressive in using a new legal concept to authorize the use of force. And I also know General Bouchard a little bit, and I can tell you that when you work at that level as a commander, you are very interested in knowing what the legal authority for these things are. As one senior commander once put it to me, I don't want my kids to wake up one day and see in the Globe and Mail that I'm being accused of being a war criminal. So it matters. It may not matter at the tactical level too much day to day, but it matters a great deal in the long run. So since Canada played a very active role in the Kosovo air campaign, we can conclude that under the right conditions, Canada will go beyond the limits of a UN Security Council resolution or the right of self-defense as a basis for authority for the use of force in an international operation. In the former Yugoslavia, the principal advantage of using force under a Security Council resolution was the international credibility that it brought to the mission. But as I've just said, the lack of a UN Security Council resolution authorizing, for example, the 1999 Kosovo air campaign did not stop Canada from proceeding as part of those alliance operations. And Canada played a very, very big role in the Kosovo air campaign. I've got a little bit of detail about what we did, but the scale of our role in all three phases of that operation was very significant. Whether Canada would have participated in the former Yugoslavia operation at all had there not been a UN Security Council resolution at the outset authorizing the overall mission is an interesting academic question. Somebody could write a paper on it, but it won't be me, and I won't go any further on that today. But certainly, in respect to the Kosovo air campaign, we, as part of NATO, were actually out in front of what the UN Security Council resolutions authorized. So compliance with the law, both international and domestic, is essential to the Canadian forces, particularly in areas of operations that may involve the use of force. The Judge Advocate General and legal officers serving as advisors on the law of armed conflict to the chain of command at all levels have that expertise and training now. The current generation of legal officers are mostly people who were seasoned in Afghanistan. But at that time, in the early 90s, very few legal officers had given advice on the law of armed conflict. Therefore, there was really very little corporate knowledge in the Office of the JAG on how to integrate the guidance of a UN Security Council resolution into the development of legal advice for Canadian Forces operations, including rules of engagement. The key deliverables that legal officers would focus on, both in the former Yugoslavia and in Libya in 2011, as I did, would be the deconfliction of Canadian rules of engagement with NATO ROE, the lawful application of Canadian rules of engagement, the no strike and restricted target lists, and in relation to air operations, especially the targeting directive. Those are just words, but for those of you with practical experience, things like use of force and self-defense, protected property, protected individuals, protection of civilians. Those are all nitty-gritty concepts which have a great deal of significance when you're actually working at the tactical level. And somehow they have to be congruent with the UN Security Council resolution. The key areas of focus of the UN Security Council resolution that were relevant at the time of the NATO Operation Allied Force in 1999 dealt with issues at a much higher level of generality. They talked about things such as authority for the overall imposition of an arms embargo on Serbia and Montenegro, or compliance with the OSCE, which Superintendent McLaren talked about, that organization, and NATO verification missions. Those were pretty far removed, based on what my colleague has informed me about, from what concerned deployed CF commanders and their legal advisors in the former Yugoslavia. The report of the Canadian Forces legal advisor present at that time indicates that he was concerned with legal review of targets, legal review of every bomb dropped, pre-mission legal briefs to aircrew, review of every command instruction, and briefing every pilot on the rules of engagement and special instructions. The legal issues that occupied him included harmonization of command and control concepts between NATO, the US, and Canada. Big one is prisoner of war status, legal classification of targets, managing relations with clients at the tactical level. And when we say clients as military lawyers, we're almost always talking about the chain of command. Delivery of law of armed conflict training, and advising on responses to pilot errors, which is a euphemism for conducting investigations. And I can say from my own experience with the Libyan mission, this is exactly the sort of stuff that I and my colleagues were doing in Italy in the spring of 2011. Okay. So in summary, the UN Security Council resolutions were concerned with a legal concept called jus ad bellum, while the rules of engagement and related direction are concerned with a legal concept called jus in bello. Jus ad bellum refers to the law relating to the authority to actually go to war or use armed force. Jus in bello relates to the law as it applies to how you conduct hostilities. The UN, NATO, and Canada all rather assume that military forces will adhere to the laws of war relating to conduct of operations. So UNSCRs generally relate to, as I said, the justification for the use of armed force, not how armed forces are going to apply it. And they rely on UN member states to apply the law in a lawful, or apply the use of force in a lawful manner. So turning briefly to Libya, 12 years after the Kosovo air campaign, another UN-authorized operation was conducted, this time over Libya. The situation that led to the operation was a civil war and not a breakup of the state like in Yugoslavia. But the role of the CF legal advisor was not dissimilar, as CF aircraft were striking regime forces targeting civilians. Of note, the second of the two applicable Security Council resolutions, UNSCR 1973, which is 17th of March 2011, which happens to be St. Patrick's Day, specifically authorized the use of force to implement a no-fly zone, and this is very significant. It specifically authorized the use of force to protect civilians. That didn't exist, or the UN Security Council couldn't bring itself to do that in 1999, so NATO leaned forward and said, we're doing it. We're doing it on the basis of responsibility to protect, and carried on. But in 2011, the Security Council resolution specifically said, implement the no-fly zone, protect the civilians, and enforce the arms embargo. So these general authorizations were then amplified by NATO Joint Forces Command rules of engagement, and General Bouchard was actually, helpfully, the commander, the overall commander in Naples at the time, and special instructions for air operations. For the Canadian forces, there was a targeting directive, and of course there were Canadian rules of engagement. In my opinion, there were three significant takeaways from Op Mobile in 2011 that developed the lessons that we learned from the former Yugoslavia, including the Kosovo air campaign. Number one, UN Security Council resolutions are cumulative, they're rarely canceled, and they're effectively impossible to get clarification on for tactical matters. Whereas Canadian forces and alliance directions for the use of force are updated frequently and thoroughly, and commander's intent is readily available. So we, the air component commander and I, and the intelligence officer, we would speak to Joint Forces Command Naples staff daily, sometimes directly with General Bouchard or whoever the commander happened to be. That would be just about impossible with respect to a Security Council resolution. We didn't have any way to phone up the UN Security Council and say, what did you mean by this? But we could do that with JFC Naples, which was great. So letting alliances do NATO's work for it is a great idea. Secondly, UN Security Council resolutions do not address legal issues most likely to arise in the field, such as detainees, the use of force in self-defense, and collateral damage assessment methodology. Canadian military lawyers have to continue to provide competent direction on these. And thirdly, legal justifications for the use of force beyond the United Nations Charter remain extremely important, and they may provide supplemental legal authority to conduct a specific mission that the UN Security Council resolution does not. So in conclusion, The evolution of the international system since the end of the Cold War has significantly influenced the legal approach to the use of force. At the time of the first Gulf War, President George H. Bush spoke about a new world order, and it appeared for a time that the UN, through Security Council resolutions, might effectively be able to stop aggression committed by states. But since that time, the rise of non-state actors and authoritarian regimes has taken the world back. There's a lot more deference now, again, to states' autonomy to act within a very broad concept of what they consider their internal affairs. And for Canada, this means it's extremely important for the Government of Canada to have maximum flexibility to lawfully deploy the Canadian forces. It's likely that Canada will continue to need legal options provided by customary international law, both settled and emerging. So I don't think the responsibility to protect is never going to come back. It had a high watermark, and it never did become recognized in customary international law. But concepts like responsibility to protect, and another important one, anticipatory self-defense, which is attacking another before they attack you, if you sincerely believe they're going to attack you, they're going to continue to evolve and be useful to the Canadian Forces and missions. New and innovative interpretations of the law inevitably collide with the status quo, but the Office of the JAG has evolved since the era of the Balkans with a much greater focus on the law of armed conflict, and it represents a source of deployable legal expertise that will ensure future expeditionary operations by the Canadian Forces will be well-grounded in both domestic and international law. Thanks for your attention. I hope that wasn't too academic.